What is meant by the rule of law? Discuss the principle of equality before the law in the Indian Constitution and distinguish it from the equal protection of the law. Or Q. Is making of classification contrary to the guarantee of right of equality under Article 14 of the Constitution valid? Ans. Rule of Law Article 14 of the Constitution of India declares that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of law. Expression equality before law is what A.V. Dicey has called rule of law. The principle enunciated in this concern by Dicey can be summed up as follows. 1. No man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of the law established in the ordinary legal manner before the ordinary way by person in authority. 2. No man is above the law. Every man, irrespective of his rank and condition, is subject to the jurisdiction of ordinary courts. So the rule of law may be defined as a recognition of the supremacy of law, the equal subjection of all persons to it. The government as well as governed are subject to the law. In Bachan Singh v. State of Punjab, AIR 1982 SC 1325 it was observed the rule of law permeates the entire fabric of the Constitution and indeed forms one of its basic features. The rule of law excludes arbitrariness, its postulate is intelligence without passion and reason free from desire. What is necessary element of the rule of law is that the law must not be arbitrary or irrational and it must satisfy the test of reason, and the democratic form of polity seeks to ensure this element by making the framers of law accountable to the people. So the rule of law is used in contradiction of the rule of man. The guarantee of equality before law is an aspect of what Dicey calls the rule of law. It means that no man is above the law of the land and that every person, whatever be his rank or condition, is subject to the jurisdiction of ordinary courts. The preamble declares the object of the Constitution to secure to all its citizens equality of status and opportunity. Article 14 embodies general principles of equality and the succeeding Articles 15, 16, 17 and 18 lay down the specific application of the general rule laid down in Article 14. Article 14 of the Constitution says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Equality before the law connotes equal subjection of all classes to the ordinary law of the land. It implies that every official from higher rank to the lower rank is under the same responsibility for every act done without lawful justification as any other ordinary citizen. Equality before the law is a negative concept. It declares that everyone is equal before law, that no one can claim special treatment, and that all classes are equally subjected to the ordinary law of the land. But it should be noted here that there is no such things as absolute equality. Law should be equal among equals. In other words, like should be treated alike. In Secretary, Haryana State Electricity Board B. Suresh, AIR 1999 SC 1160 it was observed that equality clause in Constitution does not speak of mere formal equality before law but embodies the concept of real and substantive equality which strikes off the inequalities arising on account of vast social, economic differentiation and is thus consequently an essential ingredient of social and economic justice. In Srinivasa Theatre v. Government, TN, AIR 1990 to SC 999 it was observed. Equality before law is a dynamic concept having many facets. One facet. The most commonly acknowledged is that there shall be no privileged person or class and that none shall be above law. A facet which is of immediate relevance herein is the obligation upon the state to bring about, through the machinery of law, a more equal society envisaged by the preamble and part 4 of our Constitution. Equality before law can be predicated meaningfully only in an equal society, i.e. in society contemplated by Article 38 of the Constitution. Equal protection of laws. The second concept, equal protection of laws, is more positive in content. This concept is borrowed from the 14th Amendment of the American Constitution. It means subjection to equal law applying to all persons in the same circumstances. All persons similarly circumstanced shall be treated similarly both in privileges conferred and liabilities imposed. Equal law should be applied to all in the same condition. In Prabhudas Morarji v. Union of India, AIR 1966 SC 1044, it was observed that to make out the case of denial of equal protection of law under Article 14 of the Constitution, a plea of differential treatment is by itself not sufficient. An applicant pleading that Article 14 has been violated must make out that not only he had been treated differently from others, but he has been so treated from persons similarly circumstanced without any reasonable basis, and such differential treatment is unjustifiably made. In Jyoti Pershad v. Administrator for Union Territory of Delhi, AIR 1961 SC 16-0 to Supreme Court, while interpreting the expression equal protection of law as embodied in Article 14, has laid down following rules of guidance to check whether any enactment passed by state is violative of Article 14 or not. 1. If the statute itself or the rule made under it applies unequally to persons or things similarly situated, it would be an instance of direct violation of constitutional guarantee. 2. The enactment or the rule might not in terms enact a discriminatory rule of law but might enable an unequal or discriminatory treatment to be accorded to persons or things similarly situated. The very provision of the law which enables or permits the authority to discriminate in certain circumstances offends the guarantee of equal protection afforded by Article 14. 3. The above rule would not apply to cases where the legislature lays down the policy and indicates the rule or line of action which should serve as guidance to the authority. Where such guidance is expressed in the statutory provision conferring the power, no question of violation of Article 14 could arise. 4. For the legislation to comply with the rule as to equal protection, it is not essential that the rules for the guidance of the designated authority should be laid down in express terms.